And welcome to the week 4, chapter 4 video lecture. Now we're going to deal with juvenile courts. We're going to find out that the juvenile court system is related to the criminal justice system, of course, because they're dealing with what I call our future felons, but at the same time, it is not a criminal court. It's not actually a criminal proceeding. It's actually a civil proceeding, as we'll see when we go into the specifics of it. Anyway, the learning objectives for this chapter are first to describe the child-saving movement and its relationship to the doctrine of parens patriae. Now, parens patriae is simply the Latin expression for the fact that the state becomes the parent, and that's a concept by which essentially when kids are doing things that are of criminal nature and they're still children, they're less than 18 years old, then the court takes over and becomes, for all intents and purposes, the lead parent, at least. Doesn't mean the parents go away, but it does mean that the court can decide on what's going to happen with these kids that are doing adult crimes when they're kids, and not the parents themselves. All right, next is we're going to actually look at listing the 5 ways in which juvenile courts differ from adult courts, and there's several different ways. We'll go through those specifically. And then we'll discuss how states vary in terms of when a juvenile may be transferred to adult court for prosecution, because it's possible, depending upon the gravity of the crime, the sophistication of the juvenile who's involved in the crime, all those factors will allow, under most jurisdictions, to have the juvenile transferred from the juvenile court jurisdiction over the case to adult court. So essentially they are now going to be tried as an adult, just the same as if they are an adult. And in those cases, then they will be housed in adult facilities as well. So, you know, what usually has to happen is you have to file a petition within the juvenile court and ask for permission to change the case to an adult criminal case. And if there's sufficient reasons for it, they will allow it, but it usually has to be a very sophisticated crime, very sophisticated juvenile, someone who essentially, for all intents and purposes, we can simply treat as an adult because they're doing things that only an adult would ever do, and shows that they've got a criminal mind, essentially. Next is we're going to contrast the 3 major types of cases that are heard in juvenile courts, and there's several different kinds. 3 in particular, we're going to go over major types of cases, so you'll see what the juvenile court actually does. Then we're going to identify and briefly describe the single most important Supreme Court case with respect to juvenile justice. We'll go over that, actually a couple of them, not just one, but we'll certainly focus in on the most important one, because since although dealing with a civil case, there was a decision basically saying that the children have a right to a fair trial, just the same as in a criminal case, including proving the case beyond a reasonable doubt, having a right to an attorney, all that sort of thing. That was an open question in a civil case, because in the civil cases there may not be any constitutional rights except the right to due process of law, which is basically generally a fair trial and not even necessarily a jury trial. All right, we're also going to explain the difference between the juvenile case that is petitioned and one that is a non-petition case. And then we're going to compare and contrast how adherents to the crime control model and the opponents of the due process model of criminal justice see the future of juvenile courts. You might imagine that they would see it entirely differently, and they do. But I think really a balance between those 2 approaches probably is the best way to go. You know, if you have very, very sophisticated criminal kids that are under 18, especially the closer they are to 18, the more likely we should be going probably with the crime control model. And then if we have kids, you know, who are much younger, first time in the system, we have a chance to do something with them to, you know, rehabilitate them, then we should probably be using the due process model. But in any event, we'll get into that specifically. All right, let's look at the juvenile courts 100 years ago. Okay, 100 years ago, we had a much different situation. We were dealing with basically the late 19th century, in the 1890s or thereabouts. We had industrialization in the country. We had people moving into cities. We had more people being pushed into smaller living facilities. There was a growing population of poor, working poor usually, and you know, barely able to make it kind of people who, of course, once you get into a poor situation, those sort of people have less reason to adhere to the law because they have less to lose. And so you always get more crime, generally speaking, in poor areas, just, if nothing else, just because of that one concept. But we were getting this happening more and more and more. We were getting all sorts of additional crime because of the first condensed nature of people generally, and then the working poor type of situation. These are situations where if you were in the working poor situation, you were probably never going to get out. You would basically be able to possibly have enough to eat and maybe a place to stay if you were lucky, and that was about all you were ever going to have. And that's assuming that there was enough work around it to keep you alive. You were never going to get an education. You were never going to get amount to anything except work for the rest of your life until you drop dead. Is sort of the idea of what it was like to be in the poor, the working poor in the cities during that period of time. And then along came, the child savers and progressive movement, and they were very, very adamant that you can't do that to children. You can't subject them to this sort of system that was going on then, and then punish them horribly for the crimes that they're committing, when in reality they really they won't have much of a choice in their lives as to what they're going to do, and they have all sorts of temptations that people of greater means do not have, and we're judging them as if they're all on the same level playing field, and they're not. Anyway, the child savers and progressive movement came with the idea that children are not bad, or not inherently bad. They are a product of their environment. So if we can change their environment, we can change the children. So the cure to all this problem of juvenile crime that was going on back then, and quite rampant, especially in the working poor areas, that we could change that by changing their environment. Okay. All right. There was also the parens patriae idea, and that is that it's up to the juvenile courts to become the essentially lead parent. In fact, in some cases, the only parent, depending upon whether the parents are actually around or not. But certainly the lead parent, so that we will employ discipline. We will employ all those things that that parents do to keep their children on the straight and narrow, basically, and to grow up, responsible, law-abiding adults. All right. So the progressives sought to change the thinking about children altogether. And they used this idea of parens patriae as part of the juvenile court system. And instead of seeing kids as basically miniature adults that are under the same standard as adults, they began to see children as less developed people, or less developed in a moral or cognitive capacity. In essence, they did not have the capacity to understand so much what they were doing was wrong. And they didn't have the brain power to sort of see things in a way that an adult can. They don't have the experience. They don't know what the world's all about, and so they don't have the ability to make the right choices. So the doctrine of parens patriae began to emerge as a way to now let's do the right thing by these kids. Let's rehabilitate these kids under the guidance and under the control of the juvenile courts. Basically to some extent bypass their actual parents and do what we know is right for them. Okay, and that was it was a good idea. It certainly makes sense that if you want to change the idea that all of these juvenile criminals are going to become future felons, the only way you're going to do that is through rehabilitation. You're going to have to convince the kids before they become adults that the life of crime is not the way they want to go. All right, so let's look at the juvenile courts, how they differ from adult courts. Juvenile court, their mindset is they want to help the child. Okay, that is a sort of a due process model kind of thought process. We are not here, as in adult courts, to punish people for doing wrongful acts, which is what the adult court is all about, which is the crime control model. We are here to help them. Yes, maybe we may have to give them consequences for their bad acts, but we're doing that to help them, not to simply punish them and go on with our day kind of thing. Juvenile court proceedings are informal. They're civil in nature, by the way, and informal. Whereas adult court, they're quite formal. They have, jury trial rights. When you have a adult court proceeding, it is very formal. You do things in very specific ways because of the needs to protect their rights and to give them a fair trial. These informal proceedings, meaning that a judge could sit there and just start talking to the juvenile, like, I told you last time not to do that. Can you please tell me why you decided to do it again? And they can talk to them in informal ways with much simpler language, of course, because they want to help the child. They want the child to understand what they're saying. They want the child to think of the judge as like their parent, rather than as someone who's just there to slam the hammer down and nail them for everything they do. Again, proceedings are based on civil law. It is a civil proceeding. That's very important to understand, because if it's a civil proceeding, we are no longer bound by all the rules of criminal procedure. Well, it turns out that the Supreme Court has put in some of those into these juvenile court proceedings, because we can and often do put juveniles into custody, and sometimes for long periods of time. But it's actually a civil proceeding, very much like a family law matter, where we're trying to teach this child to become a responsible, law-abiding citizen before they become an adult. Also, the juvenile court proceedings are secret, so that we can tell the juvenile that if they do go straight, it'll never be known that they did these criminal acts. They'll never have a criminal record, going around with them for the rest of their lives. And so long as they're not sent to adult court for any of those crimes while they're a juvenile, then yes, that's in fact the case. You can't get into a juvenile record. Now, police can get into it, but they can't use it for employment purposes and that sort of thing. Adult courts are all open proceedings, and the reason why they're open proceedings is we don't want the government prosecuting people where we can't go in and watch to make sure the government's doing it right. We don't like kangaroo courts, and we don't want the judge or the court system to become the tool of someone who wants to harass people and have unjust prosecutions. All right. Also, juvenile court, there is no right to a jury. Where there is a right to a jury for adult courts, that's actually guaranteed by the Constitution. But in juvenile court, since it's a civil proceeding, there's no right to a jury. Okay. So again, although civil, it's often dealing with criminal matters. But for a person who's not considered to be quite capable of understanding what they're doing to the extent an adult can understand. All right, let's look at the CASA program. The CASA program is a very well run program. This is where we actually get volunteers to come in to the criminal justice system, the juvenile court system, and they sort of now befriend the juvenile who's been accused of crime, and both before they're adjudicated and even after, especially after. And they advocate for the child. It's a child advocate process. So they go on and they're specially trained so that they can help the child psychologically in other ways, sociologically as well. They go into the child's life, and they visit the child often. They find out what kind of things are going on in the life, and find out, advocate for maybe this child needs some resources or services that are available, and they will go to the juvenile court and they'll ask that they be ordered for this child as ways to help the child. So they are essentially representatives of the child that are not actually legal representatives, but they're sort of factual representatives. They're people who have gone into their life and actually looked at them in great detail and have good information for the judge from the point of view of what's best for this child. And so if you wanted to know what was necessary to rehabilitate a child, you'd have to have that kind of information. So this CASA program is a very good program just for that reason. And it works wonderfully to the extent it can help us. To the extent that juveniles can be helped, CASA is instrumental in making sure they get the right kind of help. All right, in the organization of the juvenile courts they're a separate court, and the proceedings are held separately, and they're held in secret. There's no secret as to where the juvenile court is and who may be walking through the door, but everything that goes on behind those doors is secret. Only family members and people involved in the case are allowed to be in the actual courtroom. And then witnesses are only there for giving the witness appearance, and then they leave. They can't sit in the audience, for instance. So in some jurisdictions, it's part of the family law court, and in others it is not. It's just separate by itself. But it is definitely a unit of the trial court system. It is a state court proceeding. Now, it's very unusual for a juvenile matter to come to the federal courts, but it has happened. We had a case of a Cuban child who was brought over here on a boat, with his mother. His mother ended up dying. She drowned on the boat that was illegally coming to the country, and the child was saved. And the child then was given to some of the family members, Cuban family members that were in the United States. But the father of the child was still in Cuba. And the issue was immigration of this child. The family wanted to keep the child, the family in the United States. The father wanted the child back in Cuba. And so it ended up having to go to federal court because of the immigration status of the child. We had to decide, are we going to send him back to Cuba, or are we going to let him stay with his relatives here in the United States? And so for one of the few times you'll ever see it, a federal court actually got in and adjudicated a juvenile matter, because they had to go and decide what was best for the kid. And that's what a juvenile court does. And so they had to use the state laws of the juvenile court to decide on that issue of what was best for that child. They finally decided he was to go back to Cuba with his father, and that's where he went. Okay, law in action. The impact of the structure. Structural differences impact proceedings, but less so than the social environment of the court. What we see here is that it's not the way the court is organized that really makes a difference, because to the child, they walk into a room that's a courtroom, and it's more of an informal sort of place than you would see in a normal adult court. But it is there is a big difference between a court that's in a rural area versus one that's in an urban area. Rural areas tend to think that they can rehabilitate children better or easier, and they will tend to do that more often. Urban areas, they see a lot of kids that do some really bad, very heinous kind of crimes. They see, constant turnover of kids, being let out of the juvenile court custody and then come out and do another crime. And so they tend to get more into the crime control mode in the urban areas, and so they impact kids differently because they just don't have as much patience with kids that are doing bad acts, especially serious criminal acts. The small matters, maybe they can deal with them, but they can't deal with the bigger crimes, and they're sort of overworked in a sense. They're seeing it too often, and so they change their point of view as a way to just deal with the fact that they've got so much stuff going on. All right, let's look at the actual caseload of juvenile courts. Let's look at the different kinds of things that go on. First, the delinquency matters are children that are committing crimes that would be a crime for an adult. That could be burglary, it could be petty theft, it could be any of the high crimes like arson, murder. It could be all those kind of things. Essentially, delinquency means that a child is doing something that is against the criminal law and would be criminal for an adult. That's 55% of the cases. Now, the status offenses are a smaller amount. Status offenses are offenses that are criminal offenses but can only be committed by someone who is a juvenile. So, for instance, possession of tobacco in California is against the law for juveniles. You cannot possess tobacco, and you certainly can't smoke it. If you were found to have a pack of cigarettes on you as a juvenile, you can go to juvenile court. You would be hit with a civil matter, but you would be hit with essentially, for all intents and purposes, what is a criminal prosecution for what is a non-jailable offense, but you will end up you would be on probation, You'll be made to pay fines. You may have to do community service, all this sort of stuff. But that's a very small amount of the juvenile court work. It's only 13%. Now, dependency is another one. Dependency is when we take children away from their parents because the child's environment is not good enough to raise the child. It could be any of a number of reasons, but typically, by the way, if you want to know what the more typical reason is, it's the drug-dependent parents that are unable to take care of their kids, and they lose their kids as a result. Now, it could be that the juvenile court only takes the child for a period of time and puts them in foster care, but it can also end up with a child being put into foster care and then adopted because the court will take away parental rights from the parents eventually. The younger the child is, the more likely they will take away parental rights within a very short period of time. So you bring in a 6-month-old, for instance, you've got a drug-dependent mother, and that mother cannot take care of this child. She may only have a few months to turn her act around and prove to the judge that she can be a good mother, or they're going to get that child adopted because they have only a limited time to get them adopted before they become unadoptable. You know, people don't typically want 5 to 7-year-old kids when they adopt. They typically want very young children that they can mold into good, solid citizens, like one that they would have for themselves. And so, if it's an older child, then they may give the mother or the parents more time to turn their act around before they take away parental rights, and depends on the circumstances. And you'd be surprised how often grandparents come in and take over the parenting of these children under the juvenile court jurisdiction in a dependency case and save the day. In my experience, that goes on many times, and it's the greatest thing ever happened because the kids stay in the family. They still may have visitation with their parents, but the parents aren't the ones that are calling the shots any longer. All right, let's look at juvenile delinquency. Again, theft, burglary, sale, possession of drugs, criminal damage to property, which is malicious mischief or vandalism. These are all criminal offenses for adults. There would also be criminal offenses for juveniles, and it would be a delinquency matter because it's something that would be a crime for an adult, and it's a juvenile that's committing it, so it's a delinquency matter. Status offenses, again, it's just something that would be illegal for juveniles to do. Running away is actually illegal in most states. Truancy, which is not going to school when you're supposed to. Possession of alcohol, possession of tobacco. Ungovernability, by the way, is a status offense. If you won't do what your parents tell you to do, or you won't do what the court tells you to do, you're considered ungovernable when that's a status offense. So they can actually put you into custody for a status offense of ungovernability and put you under the control of the court. Curfew violations are another example. Again, adults are not under curfews, but juveniles are. All right, let's look at children in need of supervision. Let's look at child victim. They're considered child victims. They are a victim of the fact that they do not have a proper family to raise them up adequately. Mom may not be around. She may be an alcoholic or drug dependent and unable to take care of the kids. You know, it's not unusual to see a mother who's drug dependent or is an alcoholic just, pretty much walk away from the kids. She will go out in the middle of the night, leaving 2- and 3-year-old kids to fend for themselves in the home, which might just be in a small flat, like an apartment. Kids sometimes kill themselves because they turn on the stove and they blow themselves up and things like that. They can sometimes be, someone can knock on the door and walk off with the kids because there's nobody there to watch them. All sorts of bad things can happen when you don't have adult supervision. And so those kind of things are just not allowed. So we consider the child to be a victim because most children, we think they should have a good set of parents. And if they don't, they're victims. They're not really, it's not their responsibility to have a good supervision. It's the responsibility of the parents first and then society second. So these neglect cases are typically what you see in the dependency cases. It's not usual, although sometimes we have that happen as well, where parents are violent towards their kids. Those kind of things are taken away very quickly if you can ever find out that they're going on. Your child dependents or your child supportive services will get in and take them out of a situation like that immediately. The neglect situation is less certain in terms of whether you'll be taken away or not. But at some point along the line, you will be taken into the system if it becomes obvious that there's a parent who is neglecting the child. Certainly, if they're hurting the child. So battered, abandoned, lack of education, lack of medical care, those are all things that happen to these children, and you would be surprised how often how long it goes on before we finally find out about it. If more people would turn this stuff in, we would have a lot fewer kids that have been victimized by this sort of thing, and they never get over it. By the way, I've seen it happen. They're sort of they're distorted for life when this kind of thing happens. So law and action, one-pot jurisdiction. This is the broad subject matter of the actual court system complicates juvenile justice itself. Basically, what goes on is that the juvenile court sees many different children with many different problems. They see dependency children, the so-called child victims, that may become juvenile delinquents because they're not being properly supervised, for instance, and may even be committing serious crimes. They see the actual kids who have parents but don't obey anything they tell them to do, and they're out there just committing serious crimes because they sort of have a criminal mind that's developed. Often they're maybe 17 years old, sort of on the edge of being an adult anyway. They see status offenses, which is just some kid, smoking some cigarettes or drinking when they shouldn't be. And so what happens is the court sort of puts them all into the same pot. And they are sort of interrelated in a sense, because you'll find that those in the dependency action become our later juvenile delinquents a couple of years later after they've come into the dependency actions. And it's not unusual for that to happen. In fact, it's sort of common. And so the court sort of starts looking at the dependency kids as not victims so much as another problem, another future felon, another future juvenile delinquent. And it sort of rubs off on the court system. And so it makes it more difficult for them to do their job of rehabilitating these kids and really working to make that happen. So that's this one-pot jurisdiction. It has to do with the fact that we're sort of putting all the juveniles into one pot. They're all sort of the same. It seems to all come from the same situation. In fact, you could almost think of the fact that if you had good parenting for children, it would be highly unlikely you would see any juvenile delinquency. You might see a status offense every once in a while, but they would be scared straight real quick the first time they were put in juvenile custody. And you would not see any dependency issues or neglect of any kind. And so, you see that cycle going. You have the neglected kid, maybe the battered kid, maybe the abandoned kid, and they become the juvenile delinquent, they become the future felons, and they sometimes become incorrigible while they're still juveniles. And it makes it very difficult for a court to say, I really want to help you, because they sort of feel at some point along the line that it's almost like they can't help because they tried so many times and it doesn't work. It's as if they were too late in getting to the child before the child became the juvenile delinquent, then later future felon. All right, let's look at the age limits for original jurisdiction of delinquency matters. Delinquency, again, is when someone that's considered a minor does an act, a criminal act, which would be criminal for an adult. And there's no consensus among the states on age. Most of them, it's 18 or under. Some top out at 15, 16, or 17. But the upper age can go to up to 18. Now, it just happens to be that's the original jurisdiction over the juvenile court. So if you are under 18 in most states that say that you're a minor until you're 18, if you do a criminal act and the police bring you in, you do not go to adult court, and you do not go to an adult custody facility either. You will go to the juvenile detention, and then you'll go to the juvenile court, because juvenile court has what we call original jurisdiction over all cases involving criminal acts by people who are under 18. Okay, so that's how the system works, and then only if the juvenile court certifies the case over to the adult court system, because the crime was very, very heinous and other factors that indicate this kid is not really rehabilitatable, then it's going to stay in the juvenile court system. Now, the juvenile court systems can continue to have jurisdiction over the child even when they're past 18. In California, for instance, they can have jurisdiction over the kid until they're 25. But they have to have done something while they were a minor before they can go into a juvenile court proceeding. All right, so let's look at some of the upper ages. If you look here in this little, I think North Carolina upper age is 15. New York is the same, which is kind of interesting. California is one of the 18-year-olds. Most states are 18-year-old. Texas is 16, Louisiana 16, Missouri 16, Georgia 16, South Carolina 16, Michigan 16. So you see this really light gray is upper age is 17. That means under 18 years old. Upper age is 15. That means a 16. You're not considered an adult. You're 16. Upper age is 16 is 17, and 17 is 18. Okay, just a little breakdown there. So what's the lowest age of juvenile court jurisdiction over delinquency matters? Well, the reason why this is interesting and very important for you to think about is at what age do we start to make children responsible enough for criminal acts to bring them into a court and get control over them? That's an interesting question because there have been cases of very young children killing their siblings. It has actually happened, and they were on camera doing it, so it was real obvious how it had happened. Mom and dad bring home a new baby, and this 5-year-old doesn't like that, and he goes over and starts smashing this little baby and kills him. Yeah, it happens. So is that something we're going to bring in the kid to juvenile court because of what they did, or do we simply say no, they didn't even have sufficient capability to understand that what they were doing was wrong? They may not even remember what they did or that it was wrong. So what's the age limit, the lowest age? Well, in North Carolina it's 6, which is very, very young. 7 for Connecticut, Maryland, Massachusetts, New York, and North Dakota. Age 8 for Arizona. Age 10 for other states. So it all depends on whether in some states it may just be that it's whatever age we think that the child has some understanding of what they're doing is wrong. And if they don't, then we don't prosecute them at all. We do not prosecute people who do not have the capability of understanding what they're doing is wrong. That's also true for mentally ill people. That's why we have an insanity defense. If you do not know what you're doing is wrong, you do not have the cognitive ability to understand it, then we do not hold you criminally liable for it. Here, let's see where California is. I don't see it in here for California. Yeah, it may be that in California that it's exactly what I was saying, and that is it's whatever age. Here it is, age 24. That's the oldest age. Okay, the oldest age, not the youngest age. This is the oldest age. So I think in California, it's just a matter of if you can prove that the child knew what they were doing is wrong, then you can prosecute them, whatever age they may be, for the youngest age. Okay, let's go to transferring to the adult court. Now, these are called judicial waivers. They're given different names, but essentially what happens is a judge looks at the nature of the case, and the prosecutor sort of puts on the case for what this juvenile did, and then has to prove that the crime is of such a high magnitude, showing a depraved heart, that this child basically is now such a criminal that there's no way to rehabilitate them. This is not going to happen. It's not possible, or not practically possible. I mean, there's just no way you're going to convince someone who's a gang member and likes to kill people that you shouldn't do that. That's not going to happen. Especially the closer they are to the age of an adult, the more likely they're going to end up being in a judicial waiver situation. So you get a 17-year-old, 17 and a half years old. They have done a murder because they're a gang member. They're going to adult court in California for sure. Absolutely going to adult court. But they still have to come into the juvenile court because you have to file your case because they're under 18. You must file it in the juvenile court and then ask the juvenile court for a waiver to adult court. That's the process. You can't do it any other way. In some places, it's a prosecutorial waiver where the prosecutor will waive it to adult court and they make the decision. In other states, it's the judge that will make the decision. There's also statutory or legislative waivers that essentially set a criteria for what will be waived to adult court. And there are some systems of automatic waivers for specific types of crimes. So let's say you might have a first-degree murder, might be considered an automatic waiver. It goes to adult court no matter what. It's possible, depending on your state laws. And then corrective mechanisms. There can be corrective mechanisms to reverse a waiver, and there can even be blended sentencing, so that, yes, we may take them to adult court for the trial, but we will sentence them to a juvenile detention facility for their sentence, that kind of thing. Because maybe they're still too impressionable and too vulnerable to be put in, let's say, an adult prison. Boy, that would, that'll do it for you. You get a little kid there that is not very sophisticated, easily, given all sorts of improper ideas about what to do, and certainly they could be able to be taken advantage of by the others in the adult prisons. Only a very small proportion of juveniles are transferred to criminal court every year, so it's only the big crimes. And the closer, again, you are to being an adult, the more likely that you would be transferred to criminal court. But it's both a combination of the sophistication of the minor in terms of criminal sophistication, and and whether there's any likelihood of being able to rehabilitate them. All right, let's look at the process and the actual case. There's two different kinds of cases. One is a petition case and one is a non-petition case. A petition case is where we actually petition the juvenile court to take jurisdiction over the matter. So it's essentially the prosecutor deciding that we need to get this juvenile court involved. There's sufficient sophistication here or sufficient circumstances to indicate that we need to have the power of the court over this child somehow, that a petition will be filed. A non-petition one would be something like the cops say, well, this kid is very remorseful. Mom and dad are really on board with disciplining this kid. They're good parents. We will not petition this one right now. We will send it to the probation department to put them under a probation order voluntarily, by the way, because they have to do it voluntarily, or we'd have to petition them. And then we'll see whether we can rebuild the kid without having to go into a court proceeding. So we have many different other sanctions. So we'll put them under probation typically. There can be other sanctions. We might even give them a small amount of time in juvenile custody and then into probation. So probation will be checking on the kid as well as the parents will be checking on the kid. And probation will be checking on the parents of the kid too to make sure they're doing their job. And then what will happen is the case will end up being dismissed without a petition ever being filed. And so it basically, a non-petition case will hopefully go to nothing. There'll never be an adjudication of any kind. Now, a petition case will end up either being waived on to adult court, where then the trial will take place, or it's adjudicated or not adjudicated, as the case may be. It depends on whether the minor wants a trial or not. If the minor does not want a trial, wants to plead guilty to what they had done, with advice of counsel and so on, then they will be given sanctions, which include up to going to kiddie prison, kiddie jail, and probation or probation. And a certain number of them are dismissed. If they complete probation successfully, they'll be dismissed as another possible situation. Same thing is true when it's adjudicated. They can be given probation. They can be given other sanctions, including kiddie prison. They can be placed at different foster care facilities and so on, and essentially whatever the kid needs, we'll give it to them for rehabilitation purposes. Let's look at the offenses cases, status offenses cases. We can, again, adjudicate a case of a status offense when it appears that we need to be able to do that. If we have a lot of truancy going on, it continues to happen over and over and over and over again, parents are not really helpful, we're going to adjudicate that one. We're going to get the court in there and involved in taking over some of the duties of the parents because it's just not happening. If it's a truancy, but it looks like we could probably solve that without having to adjudicate it, we will let it go to probation, where they will set up a program for the parents and the child, and if they successfully complete the program, then the case will be dismissed. They can also have other sanctions, including juvenile custody for a period of time, if that's appropriate, but without the court being involved, because without adjudication, a court cannot get involved in doing anything for the child, except very preliminarily, pending the adjudication of the case. All right, let's look at some of the courts' controversy and reducing crime kind of issues. The question is that should juveniles be tried as adults just generally? What do you think about that? I'll tell you right now, one of the problems of trying them as an adult is if you want to teach kids to be criminals, put them into an adult custody facility, and you will be training them for sure to be a criminal, because they're around other criminals. They're going to be taken advantage of physically, mentally, emotionally, and that sort of thing. That's the kind of thing that you better be very careful of if you want to do that, because if you want to try and rehabilitate a kid, you have to keep them in a facility where there are only kids involved, and there are people there who are trying to help them rather than punish them, because otherwise you don't have a chance. So if your answer is yes, under what circumstances would juveniles be prosecuted as adults and for what crimes? Yes, sometimes I think it's appropriate that we send certain juveniles off to adult court, because for all intents and purposes, they're no different than an adult, and you're not going to be able to rehabilitate them. There's no reason to continue the juvenile court jurisdiction over the case because it's meaningless. It's actually going to get in the way of doing what we need to do as a society to keep people under control. Sometimes punishment is the only way we can even attempt to get certain people under control, because they have a criminal mind at some point along the line. If your answer is no, what would you suggest to strengthen the rehabilitative efforts in the juvenile court? How would you do that? In what ways are your recommendations similar to or different from the existing practices that were going on right now? Because if you're in juvenile court, they're still trying to help you. Otherwise, they would be violating the purpose for which juvenile court was created. So in forming your answer, also consider the following question. Do you think that the recent decrease in juvenile crime, particularly violent crime, is temporary or long-term? In essence, are we doing the right thing? Is what we're doing actually working? If it is working, maybe we should not be trying juveniles as adults, at least not as often, and then only in the most egregious of crimes, that kind of thing. So think about that. All right, also consider gangs in your city, in your neighborhood. What kind of crimes do they commit? How old are the kids associated with those gangs? Sometimes you get 12-year-olds that are actually committing robberies, burglaries. It's very common for young children, 10 to 14, to be committing burglaries. Those are very dangerous crimes. These are burglary of people's homes. You burglarize someone's home when they're home, you're likely to get yourself into a gunfight pretty quick, and someone's going to get killed. It might be the burglar, or it might be the resident, or both. Very violent crime, or potentially violent crime. Even though the small kids are doing it, and they're being trained to do it, often by the gangs. What should you get done to fix this kind of problem? Those are very important questions. Should these kids be charged as adults and transferred to adult jails and prison? Why or why not? Again, all these sort of things come up. Are you part of the crime control model, or are you part of the due process model? Are we trying to rehabilitate the kids as a way to reduce crime, or are we going to go out and punish every person who does something wrong as a way to try to reduce crime? That's the real issue. So the due process in juvenile courts, let's look at due process. That is the right to due process. That means a right to a fair trial in juvenile courts. There are some key court decisions that have come from the Supreme Court. First, certainly the juvenile has a right to notice that they have been filed against, and they will be given notice, either because they're arrested and they're brought into juvenile court, or the court will actually tell them what charges have been filed against them, or perhaps they will just be sent a letter if it's not that serious of a matter, but they'll get notice of it, and they're required to. You can't defend yourself. against false charges if you don't know that the process is going on. You have a right to counsel, and if you can't afford one, we have to pay for one as a society, because we do not want people railroaded through the system without counsel, and without counsel you really don't have a chance. You have a right to confront and cross-examine witnesses that are called against you, just like you would in a criminal case. You have the privilege against self-incrimination, just like you would in a criminal case, even though this is a civil case. By the way, you may have the privilege against self-incrimination, but in a civil case, you can essentially be punished for using it, because they will say that if you will not answer the questions, then we're going to decide every question that you would have been asked about against you in a civil case. But that's not true for juvenile civil cases, because there's sort of a hybrid in between criminal and civil, because they are going against juveniles for criminal acts, but it is a civil proceeding, so it's sort of gestalt to both sides kind of thing. All right, In re Gault, big decision, big decision. It was an Arizona case. This 15-year-old Gault was making lewd phone calls to a neighbor. It was taken to a children's detention home with no effort to contact the parents. No records of what was happening were kept over the next few weeks. Witnesses were never present, and in a hearing he was found delinquent. There was a lack of procedural irregularities of all kinds. The ACLU brought a case to the Supreme Court, and the due process requirement was put into place for juveniles. Now, if this was a true civil proceeding, these kind of irregularities would not have implicated any constitutional rights. But because we have the juvenile court that's adjudicating criminal matters in a civil proceeding, and these juveniles can be subjected to custody time, the Supreme Court says, no, you're going to have to give them very similar rights to what a criminal defendant would be. Because again, in a civil case, you're not entitled to all of the constitutional rights that you would have in a criminal case. You have a right to due process in a civil case, but that's pretty much it. The rest of the rights are only reserved for criminal cases. Okay, then of course the Juvenile Justice and Delinquency Prevention Act of 1974 was passed by Congress. It first deinstitutionalized status offenders. You cannot put status offenders into custody. So the kid's smoking the cigarette. Yes, he's going to go to, he won't go to juvenile hall, but he will go into a juvenile court at the worst. He can be fined, he can be given community service, he can be put on probation, but he cannot be put into custody. Okay, and that's because we don't want status offenders to end up being taught to be criminals when they're put into even juvenile facilities. These are offenses that are usually not that big a deal, although drinking can be very much so. You know, that kind of thing. But otherwise, it's something that is only a crime because a juvenile is doing it. It would otherwise have been legal for an adult to do. All right, juveniles are charged with criminal acts. They cannot be jailed with adult inmates. That means you cannot, until the case is actually sent to adult court, because the juvenile court allows it to go to adult court. All juveniles must be housed in juvenile facilities only. It also has had a significant impact on juvenile court systems for how they operate, and it has probably something to do with funding as well, because there's quite a bit of funding from the federal government now on trying to rehabilitate juveniles. They think that's a good place to be putting our money to prevent crime in the future. Okay, and there's many of those things that actually go on. Okay, next is the courtroom work group. Now, the courtroom work group is all the people involved in making decisions in the juvenile court. First, of course, you have the judges, sometimes hearing officers who assist the judge, but usually just the judge. You have the prosecutors, of course. You have the defense attorneys. You have probation officers. These are the key players. The judges do the same thing in juvenile court as a judge would do in criminal court. They referee the action. They decide on sentencing. They try to do the best they can to decide on what was the best for the child in terms of rehabilitating the child, including discipline type situations, including custody time. But you have prosecutors. They are the ones that file the actions in juvenile court, and without them, you don't have a juvenile court proceeding. And so they are essentially the instigators of the action. They want the court to take jurisdiction over them. They may also ask that the juvenile court transfer those matters to the adult court. The defense attorneys have sort of a secondary role. They are basically there to try to get the best deal they can for their clients, as you might imagine, even in criminal cases, and certainly to represent them if there is a trial, which might be the best way for them to deal with a situation. But the probation officer is a key player because they are the ones who are responsible for the rehabilitation of the minor. And that is the purpose of the juvenile courts altogether. And therefore, what they have to say about what is the proper way to rehabilitate this minor, or whether they can even be rehabilitated, will have much influence by the probation officers with the judges, because they're the ones that are, have the information. They're the ones that have seen the family environment. They're the ones who have all the training in sociology and psychology and that sort of thing, so that they can inform the court of what the problems are with this child, what are the proper ways to deal with the child who's a juvenile delinquent. What are the steps in the juvenile court process? Well, in a delinquency case where we have a minor committing a crime that would be a crime as an adult, then we typically would have the crime actually taking place. There would be an arrest, which is sent as a summons. We bring them into court once they're arrested, assuming that the prosecutor will petition the case, by the way, because the prosecutor may not. They may send it off to probation on a non-petition. But if they do, in fact, take the case, then there's an intake process that goes on to decide on whether this minor should be petitioned or not, and what we should do with this child. Is it proper to file a petition or non-petition type of situation? And then there's a detention hearing. Once if they come in arrested, there's a detention hearing to decide on whether we should continue to detain them for a period of time, because maybe letting them out would just aggravate things. Maybe there's not sufficient good, responsible parents at home to keep them under control. Maybe there's other factors that might mean that they should or should not be in detention until after they've been adjudicated. And then there's a petition filed. During that period of time, we're still wondering whether we're going to file a petition. Let's assume now we have a petition filed. That means that the prosecutor thinks the case should be under the juvenile court jurisdiction, so that the juvenile court will take control over the minor. And then we have conferences in which the juvenile court, the prosecutor, the defense attorney, and probation get together and try to figure out what is the best thing to do with this child under the circumstances of what we have seen. They also talk about the provability of the case to see whether it is likely this should go to an adjudication or not. If it's a marginal case, maybe the defense attorney will say, let's go to trial because, I don't think you can prove your case. If it's a dead bang case, then we're really not dealing so much with the issue of guilt. Then there's a little bit of evidence gathering that can go on. You can gather and you can also suppress evidence, so that the prosecutor may be gathering evidence, the police may still be gathering evidence on the case, but the defense attorney might be trying to suppress evidence because, again, the same constitutional rights, generally speaking, that you have in a criminal case, an adult criminal case, are also applicable to juvenile proceedings, even though the juvenile proceedings are civil matters. And then, we finally get together before we actually go to a trial in this plea bargaining process. It's actually a formal plea bargaining type of work group where the judge, the prosecutor, the defense attorney, and probation get together, and they talk about the case to see what they can come up with in terms of a proper resolution. So probation will often say, if the child is found to be if the petition is found to be true, we would recommend the following type of rehabilitation. The defense attorney might say, well, listen, if you'll recommend a slightly different rehabilitation plan, we will agree to admit the petition. And so there's a bargaining process going on. The prosecutor, of course, has to get involved in it also. If they are vehement against what's going on, then they might not agree to it. And that might put some influence with the judge. The judge can also just do whatever they feel like doing, even if the prosecutor doesn't like it. And then you may have an adjudicatory hearing where the prosecutor puts on the case and the judge decides the case without a jury on whether the case is proven beyond a reasonable doubt. If it is proved beyond a reasonable doubt, you'll have a disposition hearing where the same thing will be going on. What should we do with this child? What's the proper way to deal with them? And then you can possibly have an appeal You can appeal to a higher court if you think you've gotten a unfair trial, and just like you can in criminal courts. So again, if you're looking at the future of the juvenile courts, the crime control model is one of the ways in which we look at juvenile courts. We have to get juveniles sort of under control to stop them from committing crimes. They often commit very serious crimes, sometimes murder. Some of the higher crimes do happen with juveniles. Burglaries, again, are one of the more common ones, and it's a very potentially dangerous crime. But they do it. They do it as if they think it's no big deal sometimes. If you're in a crime control model mode, it's all about punishment. Give them consequences. Continue to give them as many consequences as we can give them. Maybe other people won't learn about it because we've got secret proceedings here. But at least those particular juveniles will see that there are consequences to doing criminal acts, and maybe we'll get them under control that way. And then you have the due process model that is more into preventing juveniles from committing crimes in the first place. And they think about crime reflecting social problems, so that if we can solve the social problems, we can solve the juvenile crime problem. And so they continue to focus on rehabilitation. Let's rehabilitate these kids. That's how we're going to stop them from committing crimes. That's how we're going to make society better and make law-abiding citizens. Okay, that's it for the juvenile courts. Again, if you have any questions or any comments you'd like to make about this learning, or if you'd like any help with it, please feel free to give me a call or email me, and I'll be more than glad to help.